Hey everyone, if we've never met before, my name is Vojchehoske and welcome to Nebraska Landlord's YouTube channel, where my mission is simple, and that's to enhance the landlord-tenant relationship through education. Today's video is sponsored by that red subscribe button, so please do me a favor, give this video a thumbs up, hit that red subscribe button, click on the notification bell, and share this video with someone that you know is in the real estate business. I would appreciate that. So as you can tell from the title of this video, we're talking about lead-based paint disclosures. More specifically, what happens if you don't comply with the EPA's regulation regarding these disclosures. And the basis for this video comes from the EPA itself, that publishes a periodical every quarter that talks about who got busted for what. And I'm going to put a link to this specific one down below in the video description. This is regarding a company. They manage a property management company that manages about 400 units in Iowa, Nebraska, and Missouri. And they settled with the EPA. They agreed to pay $40,800 in civil penalties for failing to do the very basic things that every landlord should know that they have to do. This law has been around since 1992. There is nothing new about this. Folks, it's easy to comply with. It's a matter of just crossing your T's and dotting your I's. I wanted to reiterate and re-educate and remind folks of what your obligations are as a landlord in Nebraska or a property manager to comply with the EPA's rules and regulation. Number one, if your property is built, your rental property is built prior to 1978, not including 1978, but 1977 or older, you must completely fill out and complete the lead-based paint disclosure for that property. Now, there are two disclosures. There's one for the sale, for buyers and sellers, and then there's one for landlords and tenants. It's actually referred to as lessor lessee, which means landlord tenants. Please make sure that everyone who owns the property or is responsible to sign it, signs it. If you're a property manager, there's a section for you, the seller, the buyer, the landlord, the tenant. Everybody has a portion that they have to complete. Make sure it's filled out completely. Along with that lead-based paint form, you must provide that tenant all documentation regarding lead-based paint, not just documentation that proves that there is some type of lead. It's all documentation, whether it's an assessment that shows positive lead results, negative lead results, whether it's an assessment, whether it was a letter from the EPA, an administrative letter regarding lead in the soil. For those of you that own rental properties in South Omaha and you were part of that Superfund site, any and all documentation, and there is no time limit. So we're talking 20, 25, 30 years ago. Anything. If there was a test that was done in 1972 and you have a copy, you have to provide it. Or if you have knowledge about that inspection, but you don't have the documentation, you still have to provide that knowledge to the tenant. So we have a disclosure, we have all these associated docs. And I understand for some of you, I have seen landlords that have to provide their tenant a stack of documents. That is what the law says you have to do. Now, number three, don't forget that blue pamphlet. Protect your family from lead in your home. Now, that blue pamphlet does get updated periodically, so you need to make sure that you're giving your tenant the correct version. Giving your tenant an older version is a potential notice of violation. One of the things. Now, here is a little risk management trick here with that pamphlet. I'm going to give my tenant the pamphlet, and then I'm going to give the tenant page 1 of a pamphlet and have them sign and date it. Because that pamphlet cover shows the version, and it also has the tenant's signature and date, and they're acknowledging receiving this version of that pamphlet. That's just one thing that I've seen several managers do as a risk management tool. Point is, you have to give them that blue pamphlet, and it has to be the correct version. Number 4, your disclosure, your blue pamphlet, and any associated lead-related documents must be given to the tenant prior to the lease agreement being signed. That is so important, because under federal regulation, if you do it the other way, if they sign the lease agreement and then you give them the disclosures and stuff, then that is a voidable lease agreement, and it allows that tenant, it's almost like entering into a contract with a minor. that tenant is allowed to terminate that lease agreement at any time during tenancy, penalty-free, meaning they're going to get any unpaid rents back and their security deposit. All right, that's under federal regulation. So make sure that you give those things to your tenant before they sign the lease contract. Number 5, we got to document or keep these files for 3 years. The IRS requires that you make available to any EPA auditor copies of these disclosures, documents, and so forth for 3 years. So you need to have 2 files. You need to have an active file and a ghost file. The active file is for all the disclosures and reports and stuff that are within that 3-year requirement. Once they become 3 years and 1 day, we're going to shift them over to the ghost file, which we keep forever. And there has been documented cases that tenants and enforcement agencies, they can bring action against the owner, previous owners, 10, 20, 30 years later. We want to be able to prove if we are sued, we want to be able to go into court and show the judge that, yes, 35 years ago, I made sure that everything was done correctly. Here are my disclosures and here are the documents that I gave my tenants. Point is, the EPA auditor only gets those that are within that 3-year period. The ghost file is never acknowledged that you have unless you get sued. And then number 6, the last one is, this property management company has to pay $40,800. There's no errors and omissions insurance that is going to pay for it. Their general liability insurance isn't going to pay for it because those insurance policies do not cover enforcement action. But keep this in mind. There is a federal regulation. The acronym is CERCLA, C-E-R-C-L-A. It's commonly referred to as the Superfund Law. It allows for the federal government to go in before a judge, a federal judge, and ask the judge to dissolve any LLCs, trusts, corporations, so they can gain access to your personal finances should your company not be able to pay these notice of violations. So from a financial point of view, we want to make sure that we're crossing our T's, dotting our I's, and doing the right thing. But more importantly, remember, lead is extremely harmful to children. Hell, lead's extremely harmful to adults, but it's really harmful to kids. So we do also have that component as well. From a financial point of view, it's important, and from the health and safety of our tenants, more importantly, it's very appropriate as well. So point is, with all of this, if you're going to be in the landlording or manager business, you need to know these regulations and comply fully with them. By now, there is no one should be getting nailed by the EPA for these type of violations. It's just mind-boggling. If you're in this business, you need to know how to operate. This is the cost of doing business. You either know the rules and regulations or you don't. And if you don't, or you don't want to comply, then turn your stuff over to a property management company. And a great property management company here in Nebraska is PPM, Performance Property Management. They are a great company. They comply with all of these rules, fair housing, lead-based paint. They do a great job. I'll put the contact information right here. Give John a call. Ladies and gentlemen, this video and the topic of this video is precisely why you need to stay informed. You do that by subscribing to the channel. You do that by joining our email list. I'll put a link down below where you can join our email list. Stay informed of what's going on. That's all I got, everybody. See you in the next informative video.